My name is Mark DeBofsky of the law firm of DeBofsky & Associates in Chicago, Illinois. And I'm here today to talk about ERISA claims and causes of action. The ERISA law, the Employee Retirement Income Security Act of 1974, has caused a profound change in the way in which benefit claims are litigated in court, as well as the remedies that are available when it's found that a benefit has been wrongfully denied. The ERISA statute primarily focuses on one statutory provision, 29 U.S.C. section 1132A, which is in the ERISA title as ERISA section 502A. What the ERISA law does in that statutory section is it creates the causes of action that are available as well as the remedies that are available when a benefit is denied. But before even getting to court, there's another statutory section that's important to keep in mind, and that's ERISA section 503, which is codified in the United States Code at 29 U.S.C. section 1133. What that provision states is that anyone whose benefit has been denied in whole or in part has the right to a full and fair review of that benefit denial. And what that means in a practical sense is that the courts have required that any employee who has had a claim for benefits denied in whole or in part must appeal that denial to the plan administrator or to the insurance company that's denied the benefit as a precondition to litigating that case in court. That appeal is subject to a very detailed set of guidelines issued by the U.S. Department of Labor. Those guidelines can be found at 29 CFR section 2560.503-1. And those guidelines detail what the Department of Labor considers to constitute a full and fair review. A full and fair review requires that the claimant be provided free of charge with the entire claim record that was assembled and led to the basis of the denial. For medical claims or disability claims, medical experts have to be consulted, and those experts have to be expert in the field in question. Because many medical claims involve medical emergencies, there are very short time frames that the regulations promulgate with respect to how quickly those claims have to be adjudicated. Sometimes even in 72 hours, depending on how critical the emergency is. And those guidelines give the claimant the opportunity not only to see the basis for the denial, but to submit contrary evidence in an effort to convince the insurance company or the plan administrator that the decision was made in error. If that appeal is successful, obviously the benefits will be paid, but if the appeal is unsuccessful, then the case can proceed to court. Now, what kind of claims can somebody bring in court? Normally, one would think that if an insurance claim, such as a life insurance, health insurance, or disability insurance claim is denied, that you would bring an action for breach of contract. Instead, under ERISA, if the claim is governed by the ERISA law, you have to bring a claim seeking the benefits that are due pursuant to 29 United States Code, section 1132A1B, alternatively in the ERISA statute at section 502A1B. That claim is essentially the same thing as a breach of contract action, but that particular cause of action also encompasses a claim for a declaratory judgment, as well as a claim seeking an injunction. There are other provisions of ERISA, such as section 502A2 and 502A3. Section 502A2, which is codified at 29 United States Code, section 1132A2, allows for plan-wide relief. So if the plan has contracted with a vendor that has essentially stolen plan assets, then an action can either be brought by the plan or by a participant in the plan seeking to recover the assets that were stolen. Section 502A3 is a claim for what the statute refers to as appropriate equitable relief. That claim can be brought either by an individual participant in a plan or by the plan itself, but the relief is limited to equitable relief, and that's equitable relief as it existed prior to the merger of the courts of law and equity in the 1700s in England. So in effect, it's limited to an injunction or restitution where funds can be particularly identified. The Supreme Court has issued a series of decisions trying to clarify what is meant by appropriate equitable relief, and they've yet to come up with a satisfactory solution. Some of those claims have involved the circumstance where a health benefit plan has paid out benefits to somebody who's injured in an accident caused by a third party, such as a car accident. In those situations, the plans often have provisions that say if they pay out benefits, they have the right to be reimbursed if the party who's received the benefits has brought an action against the third party who's caused the injury, such as a personal injury action. In those cases, the plan can bring an action under Section 502A3, but only if there's a provision in the benefit plan that permits for recoupment or reimbursement of the money that's been paid out. If there is no such provision, the plan is not entitled to seek reimbursement because that would be what the Supreme Court has characterized as a legal claim, which is outside the scope of Section 502A3. And because ERISA has another provision in it that preempts any state laws that relate to employee benefit plans, 29 U.S.C. Section 1144, the preemptive effect of ERISA would bar the plan from bringing an action for breach of contract. Likewise, a plan participant or beneficiary is not able to bring a claim for breach of contract. The beneficiaries or participants are limited to bringing claims only as permitted by the ERISA statute and as contained in Section 502A of ERISA, which is alternatively titled 29 United States Code, Section 502A. I know this sounds extremely confusing. It is. And this is an area that really calls for an expert and somebody who is experienced and familiar with the ERISA law in order to parse through these claims and know what needs to be done and what actions can be brought. This is not the type of claim where you want to hire the guy who has the corner office and handles wills, estates, trusts, personal injury, criminal cases, and a variety of other things. This is a highly specialized area where the rules seem to change every minute. So ERISA claims and causes of action are very specific, but the primary sources, as I've indicated, are the ERISA statute, Section 502 and Section 503, which are codified at 29 United States Code, Section 1132 and Section 1133, as well as the very detailed regulations at 29 Code of Federal Regulations, Section 2560.503-1. And by following those guidelines and understanding what is available and what isn't available under ERISA, hopefully mistakes can be avoided. But it is critical when there has been a claim denial that there be a pre-litigation appeal prior to going to court. The consequence of going directly to court could be that the claim at issue, the merits of that claim, are never addressed by a court, which is something to be avoided at all costs. So in conclusion, ERISA is a very unique and separate law that creates its own causes of action and remedies that are specific to the ERISA statute. And ERISA claims can only be brought under those provisions and within those guidelines and subject to those remedies. Any other claims are likely to be dismissed.